Hey everyone, it's Rob Ryder. Today, let's talk about the obvious: that Esquires are enemies of the United States. And in my opinion, while the United States is under military rule, which it is, veterans are officers of the civil government. This is why they don't want us to have our ID card, right? Our Geneva Convention ID card, because then we would actually be recognized as officers of the military government. And anyways, whenever I contact these people now, this is for any veteran, right? You should be using your title, whatever you were. So, Staff Sergeant Robert Allen Retluski, United States Army veteran. That's who's contacting them, right? So, when I'm trying to contact the court or the township or the post office or all these other places I'm dealing with, I'm going your official capacity, right? Claim it. Because Esquires are enemies of the United States. These are the people that have taken all the offices in politics, but none of them have taken an oath of office to hold the office. They simulate legal processes under color of law, and that's a frickin' crime against the people of the United States. And so we need to call them on it. And, so that's what I've been trying to do it for quite some time anyways, but it just came to light again where we have these 13 men in Michigan that have been arrested for apparently planning to kidnap the governor of Michigan. Well, I beg to differ because Gretchen Esther Whitmer is not the governor of Michigan. She didn't take an oath of office. She's an enemy of the United States. She should be arrested. In fact, I contacted that Berry County? Yeah, Sheriff's Department. Said, come take my testimony. I'll give you the evidence. Right? That she's not the governor. So, anyways, I don't know any of these 13 people, but I know. But what I do know is, we'll get into this more here in a minute, that 2 of them were Marines or had been Marines, and I say once you're in, you're always in, because they never give you a order, right? That you need to be truly released from the military. You need an order, not a DD-214. If you read a DD-214, it just says you've been released from active duty, but you're still in the military. And so them boys should be going to a freaking court-martial, right? And that's what I want to point out, is they need to be asking for a court-martial. So one of the things I'm going to do this week is contact the judge and say, hey, you got to let these guys have a court-martial, right? The civil government of this military-ruled United States has spoken. Staff Sergeant Robert Allen Retluski, United States Army veteran. See if she listens to me, right? Just write the judge. She may not know these things because the attorney brought the... See, the thing about a court case is it's the attorney for the plaintiff or the prosecutor, whoever you want to call it, that's bringing this charge to this particular venue with with whatever you see sitting there and a person sitting up there that's supposed to be a judge, right? This image that we've been given. But what matters is, well, does that person sitting up there have the authority to hear this matter that's concerning my life, liberty, or property? And if you're a citizen of the United States, well, then they have to have taken an oath that satisfies the 6th article of the Constitution. And I've pointed out numerous videos that oath is found in the first law passed by the first Congress after the ratification of the Constitution. 1 statutes at large, page 23. Right, which was later codified in the United States Code as Title 4, USC, United States Code, Section 101. I, Robert Allen Retluski, do solemnly swear to support the Constitution of the United States. Period. That's all there is to it. Without the that's not in there. But the rest of it is. Right? You need to put your full legal name in and say this one little sentence, and that's the oath that satisfies 4 USC 101 or 1 Stat 23. And it's separate from any other oath that may be required because of your frickin' office. Well, they ain't taking that oath, so they're not officers of the United States. They don't have any authority to say anything to you if you're a citizen of the United States. The plaintiff's attorney brought the case to the wrong venue. And that's not our fault. Right, that's my point. Right, this is what Esquires do. They simulate legal processes. They don't do it by the book. They just do it by their customs, right? And their custom is to do it in a way that they're going to win, and they're going to trick you by telling you half-truths. So they won't, in their book, they say, well, we didn't lie to you. But in reality, in God's book, they'd say a half-truth is a lie. And this is what they're very good at. They only tell you shit up to the comma. So, so it pisses me off a bit, and I'm going to talk about it some. So anyways, I had been doing some videos here recently on all these different things going on, and because of what happened, I've added one more to it. So, hey, if you can donate to help keep the lights on, please do, because I'm really busy, trying to help my fellow man. PayPal account, robryder@AOL.com. Or you could send it to this address, which technically this isn't my address, which is another thing we'll be getting into, but it's the one that gets the mail to me, so it'll work. It'd be Robert Allen Rytlewski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. Okay, if you want to email me, courtofrecord@AOL.com. Phone number 616-712-6179, and about Esquires and what's going on in the world today. So, let's see here. Esquire, a title applied by courtesy to officers of almost every description, to members of the bar and others. No one is entitled to it by law, and therefore it confers no distinction in law. However, it's conferred on officers, right? So you need to be an officer or something to be an esquire. So we can see here that in England it is a title next above a gentleman, which is a mister, which is what they want us to be, but below a knight, which would be the judge. Canon records of four kinds, esquires, particularly regarded by the heralds, and it gives the names of them. But at the end of the day, esquires, by virtue of their office as a justice of the peace, and some who bear any office of trust under the crown. All right, so an esquire holds an office under the crown, which is United States of America. Not the United States of America, not United States of America, the style and name that's on the passport, right? That's King George's venue. Treaty of Peace, 1783, they said so. Okay, that's different than the United States, which is, where we're supposed to be. It's a territory, and it has a government, and that government is supposed to have a constitution that we're supposed to be protected by. But they have us using an improper, esquires now, have us using an improper address. And so technically we have volunteered to leave the jurisdiction. And they gave us an address, a residence address. This is actually in the United States of America. It's not in the United States, or the United States of America, which is the United States of America. That's the confederation of states created under the Treaty of, the Articles of Confederation. Right, the very first article, the style of this confederation shall be the United States of America. And that's what's on money. The United States of America is on passports. Right? So the property's in one venue and the persons are on another. And it was done by esquires as part of a scheme to take our property, to keep control of us. And they have us in this system now where the judges are the law. It's like we've given up our rights. But we just need to get back to the republic, and it's, I believe it's the judges that can help us do that. So, yeah. Let's see where we can go from here. So give me just a second to put some things together. Okay, so in my last video, which was miscellaneous cases in the mother court, I had shown that in the Southern District of New York, they had the court they call the Mother Court, which is supposed to be the, it's, well, let's look at some of these things that they called it here. See if they're going to come up, right? That the Mother Court, older than the Supreme Court, the Southern District of New York is sometimes called the Mother Court, and the Sovereign District because of its reputation for self-rule from Washington. In that sense, Mackman is appropriate public face for the court's new chief. The mother court is the gold standard of trial courts in the United States. It is the country's crucible of justice and the continuously unfolding history of our nation. All right, it's from the American Bar. Oldest court in the nation, the mother court. All right, that's what they call themselves. This is on the, New York Southern District U.S. Courts Government's website. They call themselves a mother court. So there's something special about this court. And one of the things they have is they actually have a cover sheet to do a miscellaneous case or miscellaneous action. I can't remember the exact word. Where normally if you go to the federal court, they give you a cover sheet for a civil action. And the civil action costs you $400 to do, $400. But a miscellaneous action is $47. And you don't even have to pay for it to start with. And so that's why I was pointing out in this video. All that to say, well, that was one of the subjects in the video that I had done. Miscellaneous cases in the mother court. But I had also shown that I was in the process of working with the post office to try to figure out this thing about the residence address that we're supposed to be putting on our driver's license or state ID application, right? Because if you have an incorrect residence address on your official identification, you've committed a crime. But no one will tell you what that address is supposed to be, right? And so I'm trying to get it figured out or that was my idea at the time, to try and get it figured out through the post office. Well, out of that came this finding this form, and all of this I just told you was so I could show you this form and then move on to say I have to do a video on it all by itself. But you should probably go download this form. How to apply for a post office caller service. Caller service, a premium service available for a fee to any customer who requires more than free carrier service. And so as you read through this thing, it's not that long, but I'm going to do a separate video on this. What this ends up doing is you have to go to the post office with 2 pieces of ID to set this up. Well, that's the same thing you do to get a driver's license or to get a passport. Right? So you're going to go and establish a service with the post office, right? Where what I'm going to say is you actually check both these boxes, right? The name of the business is Robert Allen Ritluski then, and the name of the owner is Ritluski, Robert Allen, if that's how they want it. But I may not do that. I'm just going to put Robert Allen Ritluski because I don't like to do things in parentheses, right? That's how they want it. They can figure it out later. My name's Robert Allen Ritluski. I might just screw that line. Right, so I'm the owner of my business, and I've talked about this in numerous videos before. My point is, when you fill this thing out, you got to give an ID, you got to give them this other information. They have to agree, check, check, check. Now they have acknowledged that you're the person that came and did this. Right, so you've just been seen in the jurisdiction of the United States and acknowledged by the post office. So yeah, it's what is the form number here? It's Form 1093C, and I'll do a video separate from this about what I'm doing exactly with this, but I wanted to mention it because it's so important that I think this is how you establish your residence so it's recognized by the federal government, because there is no state government. None of these people have an oath of office. Right? So... okay, that's what I want to do on that. But what I'm going to spend some time on now is what's happening here in Michigan. Which, let me go this thing here first, right? 2 men charged in plots served the U.S. Marines. So U.S. Marines confirmed Saturday that 2 men charged in plots against Michigan government spent time in the military. Well, again, they're not the government. These people are all pretending. I don't care if it's the governor, the Secretary of State, the Attorney General. None of them have taken the oath that's in 4 USC 101. I should have already had this pulled up so we could, verify that Ritluski's telling you the truth. Hussars don't want to lie to the military. I'm trying to do it by the book. So, They passed a law way back in 1789 that eventually got codified into the code in Title IV, where it says every oath of members of legislature and officers, every member of a state legislature and every executive and judicial officer of a state. Stop for a second. Who would that be? Well, it'd be the governor, the secretary of state, the judges, the justices, the attorney general, the treasurer. Technically, it's anybody whose office would have been created under the Constitution of the state. Right? If you're going to claim any authority as the government in the United States, you're going to take this oath, or you don't have any authority. Right? Shall, before he proceeds to execute duties of his office, take an oath in the following form, to wit, I, Robert Allen Orlowski, do solemnly swear I will support the Constitution of the United States. Now, if there's other oaths required, they have to take it. Attorneys have to take this. Judges have to take this. Township supervisors need to take this. Dog catchers need to take this. Right? If they're claiming an office in the government of the United States, and they're given any authority, right? Because an office is different than an employee. They may be employees, but it's a different class of employee. I don't know how best to say it. I'm just saying, if you're going to say I got to do something, I want to see your oath of office because, I'm a veteran. I have an oath. Mine's still good. I'm going with my oath that I'm an officer. And so they have to prove to me that they're an officer. And they can't do it. And so they don't have an oath. So these guys really didn't do anything against the government. They did it against people pretending to be the government. Yet, the people pretending to be the government are the ones in charge of the propaganda machine, and they're spewing out their bullshit that, we have to put up with at this particular time because the Army hasn't come to our rescue yet. But at some point it will. Officials are aware of the circumstances surrounding. Where is this one guy? This guy here. All right, Morrison was a Lance Corporal and served in the Marine Corps Reserve from 2015 until Thursday, the day he was arraigned on state charges. The Marine Corps said his departure from the reserves is unrelated to his current situation. So maybe they waited to this day to do this so that he wouldn't be in the Marines, or that's what they're saying. And what I'm saying is both of these guys are still in the Marines. Neither of them has ever gotten an order, an administrative order, releasing them from the custody and control of the Marines. And until they have that order, they're still in the Marines. And so, this is part of this idea that we're all being carried missing in action or some kind of missing status, and we're actually all still being paid, and that's what all these other people are living off of is, what is really ours. Except they stole our identity. And we're still in the military. So, what they did here in the Western District of Michigan, 6 arrested on federal charges on conspiracy to kidnap the governor of Michigan. She's not the governor of Michigan. And the guy that did this is not a FBI agent. And the attorney that did this is not really a United States attorney. None of these people have taken the oath that's in 4 USC 101. But it didn't stop them. They still wrote up a criminal complaint to the United States District Court. Right, so there's the case number, 120 MJ. I'm not sure what MJ is yet. 00416 SJB. Why, I, the complainant of the case, state that the following is true to the best of my knowledge and belief, that on or before June 20th to the present, but on or about the dates of June 20 to the present, in the county of Kent and elsewhere in the Western District of Michigan, the defendants violated 18 USC 1201, conspiracy to commit kidnapping. All right, now it doesn't say kidnapping of the governor, just kidnapping, which is a different thing, right? Because again, they're not saying she's trying to do anything with the governor. Just kidnapping, period. Criminal complaint is based on these facts, right? We can believe that's his signature. But it says it was sworn to me and signed in my presence by this judge. And so, as I was pointing out in my other video, this is how you do an affidavit. You don't have an attorney give you an oath. You have them sign that it was sworn and signed in their presence. Right? This is an acknowledgement certificate. This isn't an oath certificate. So Richard Trask, some special agent, it doesn't say he was a special agent of, right? I mean, that's nobody's title. It's a partial title, and that's not his full legal name. I'm sure he has a middle name. So, whoever this man is in real life didn't really do this. It's a simulated legal process. And it goes on to talk about the things that they may have done. I, Richard J. Trask II, being first duly sworn here to depose and state as follows. Well, this man hid his identity. That's not the name on his driver's license. Right? That's not your identity. You can't use that to identify yourself. I'm a special agent in the Federal Bureau of Investigation, FBI, and have been since 2011. Well, let me see your oath of office. Right? I'm sure that he filled out a thing called the Standard Form 61, which doesn't have the oath that I've shown you, the one that's, I state your name. It has an oath that is in 5 USC 3331 that's been bifurcated, and that oath says, "So help me God," which is a religious test, so it cannot satisfy the 6th article of the Constitution. And until you satisfy the 6th article of the Constitution, you can't be anybody in the government. You can't be president. So you certainly can't be a fucking FBI agent. Anyways, this is, you can get all this if you want to look, right, by going to the Western District of Michigan's website. And, this is still new stuff, so it's on there. Thursday, October 8th. Click on complaint. It'll take you to this document. So my plan is, forgetting all this other stuff for a minute, was I was saying, well, who is the judge, right? And what is it what's going on here? Here's the charge, conspiracy to commit kidnapping. And this is supposed to be the attorney that's doing it, counsel for the United States. Well, there is no Niles R. Kessler, right? Niles R. Kessler is not an attorney licensed to practice in the state of Michigan. That name is not going to be found in the roll of attorneys for the court. It's not going to be found on his certificate of, the roll of attorneys for the state of Michigan or for this court. Right? They don't let you use a middle initial. That's not the name on your license. And I haven't done it yet, but I'm sure if I went to Pacer and looked this up, there's probably another court case that has a similar number to this. There's actually 2 court cases going at the same time. Right? Plan to kidnap Governor Whitmer. Excuse me, she's not the governor, as I've been pointing out. But I do want to go look that up. Hang on just a second here. Okay, so if you have a Pacer account and you went into West Michigan, right, and put in this, let's say Daniel Harris, that's the name I used, right? And I went into Pacer and looked. And sure enough, there's 2 court cases against him. Right? They 416 SJB-5 and one without a dash. But they're 2 different court cases going on right now against this man, but they're only showing one of them. Right? They're showing this one. They don't show this other court case, but it exists and it's going on. They did the same thing to General Flynn. They do this to everybody. When there's a criminal case, they have 2 court cases going on. Well, that's, there's something wrong with that. That's like double jeopardy right off the bat. You're being tried twice for the same fucking crime. But one is USA versus Fox. The other one is just Daniel Harris. Well, they can tell you what the difference is. But this is what Esquires do. That's why Esquires are enemies of the United States. It was an Esquire named John Glover Roberts, Jr., who recited to President-elect Donald John Trump the oath of office in Article 2 of the Constitution, except he did it wrong. Because he had Trump put his name in at the beginning. Donald John Trump. They said it loud and clear. But that isn't in the oath of the second article. And then at the end, he said, right, Roberts led off with saying, "So help me God." Right? So it was considered part of the oath. It wasn't like Trump said that on his own after the oath. It was said during the part where the Chief Justice was, supposed to be given the oath. Well, that's an Esquire. Right? He made sure that Donald John Trump isn't the President of the United States of America in accordance with Article 2 of the Constitution by giving him an improper oath of office. And I went back and looked. They did the same thing with Obama, right? So I don't know how long this goes back, but, the oath that's in Article 2 doesn't say put your name in. The one that's in 1 Stat 23 says to put your name in. And the president would have to take the oath of 1 Stat 23 because it's for all executive officers of the United States. And he's the chief executive officer, and he's the commander-in-chief, which is another executive office. So, right, this is the bullshit that we put up with. This is why you got people in the streets going crazy, like Antifa. They have a reason to be upset. Destroying stuff isn't going to fix it, but, making this shit stop is what will fix it. Don't let an attorney run 2 cases at the same time against somebody. But that's what's happening. So, this is being done by an attorney. So I'm going to go point this out to this, this person playing judge. As Staff Sergeant Robert Allen Orlowski, United States Army veteran, I'm in the military. I'm in the military government. I'm saying you can't do that. Because in this court, wherever this is going to be heard, will be a gold-fringed flag. Right? And a gold-fringed flag is a military flag. It's, basically it's an Army flag. It's covered in Army Regulation AR 840-10. Down here in your old Section 2, Chapter 2. Section 3 of Chapter 2, right? National flags listed below are for indoor display and for use in ceremonies and parades. For these purposes, the flag of the United States, didn't say United States of America, the flag of the United States will be a rayon banner cloth or heavyweight nylon trimmed on 3 sides with gold yellow fringe. Then it goes on to say where this flag can be displayed. The flag of the United States is authorized for indoor display for each office, headquarters, organization authorized a positional color, distinguishing flag, or organizational color. Well, that would be military. Organization of battalion size or large or temporary, permanent, or not otherwise authorized flag of the United States. Well, that would be military. Military offices not otherwise authorized an indoor flag of the United States for the purpose of administering oaths of office. Hey, that sounds like military. Hey, military courtrooms. The U.S. Army element of Joint Command, military groups of missions, one flag is authorized for any one headquarters operating in a dual capacity. As you can see, that's a military flag, right? So when you go into a courtroom that has a gold fringe flag, it's a military tribunal. Or it has the ability to, to try a case as a military tribunal. Now, judges can judge many venues of law, but it needs to be specified which one you're in. And I'm saying because that's already a military tribunal that these guys that are the Marines need to say that they invoke their privilege for trial by court-martial. And that's what I'd like their attorneys to do, right? But if they can't do it, I'm going to write the judge anyways. Right? So I'll just write the judge. But what I noticed on this complaint here, so this complaint doesn't have the other, it only has Daniel Harris was one of the 2 Marines. The other Marine isn't on there, right? That would have been Morrison, the guy that just got out. How come he's not on there? What's he being tried under? So Kenton County Sheriff, Daniel Harris is shown. Whitmer. What's this other guy's name? Let me go check on this other guy real quick. Hang on. Okay, well, that's interesting. They're not trying Joseph Morrison, which is the brother that is still a Marine, but apparently had just been discharged last Thursday. He's not being charged in this court, so I have to find out what's going on there. But there, again, this is just to show you what kind of stuff happens in the background that they don't talk about in the courtroom. So, us trying to do things like attorneys that, this is why they want you to, this is why when they take you to court to a civil case, right, they want you to file motions and do what they do as an attorney. The problem with that is that's what they do. They file motions, right? That's called motion practice, and that's what attorneys do. But we're really not attorneys. We're not licensed in the law. We can't write a order to show cause, but an attorney can, right? Because he can write a legal document. Now, the judge has to approve it, but he can still write it. But we can't even write it because we don't have the authority to write legal documents. A paralegal has the right to do that, but you can't find a paralegal that'll work for you. They're only working for attorneys. All right, so what are you left with? Well, you're left with getting the judge to do it. Right, and just because I had found this, I wanted to show it again. In the Supreme Court of the United States, if you went to the Supreme Court's website, you find these rules. And if you look up Rule 45, right, all process of this court issue in the names of the President of the United States, right, whatever the Supreme Court is. Whatever that ends up being, that's when you know you're in the Supreme Court, when the process issues out in that name. But they have another one, which is Rule 40, which is for veterans, right? That a veteran suing under any provision of law exempting veterans from payment of fees or court costs may proceed without prepayment of fees or court costs or furnishing security, therefore, and may file a motion for leave to proceed on papers prepared as required under Rule 33.2. But they never really say what court that is because SCOTUS isn't the Supreme Court of the United States. They don't issue paperwork in the name of the President of the United States, like Rule 45 just said. SCOTUS doesn't do anything except give its opinion on something else that happened, but it's not issuing out its own process. Right? All process of this court issues in the name of the President of the United States. Okay, show me something from SCOTUS that has the President of the United States name on it, other than being a frickin' defendant. So, what court is it that issues process in the name of the President of the United States? You find that court, you found the Supreme Court. And when you find that court as a veteran, well, now you get to put your stuff in for free because, we got our own rule. We got Rule 40. And so I'm hoping then that what this court is, it's the mother court. Right? It's the one in New York, the one that was created first even before the Supreme Court. The Southern District of New York. And that by applying for a petition for an order to show cause or a petition for redress of grievance is how you get something done. And that's what I'm trying right now, and that's really what this video was going to be about, was what I've submitted into the court, and I'm waiting to get a court case number. So we'll talk about that next. Hang on. And just real quick, this is that law that 1 Stat 23, this is the first statute, right? The very first law, an act to regulate the time and manner of administering certain oaths from the first Congress after the ratification of the Constitution. It says, being enacted by the Senate and representatives of the United States of America in Congress assembled, that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the following form. To wit, I state your name, you solemnly swear or affirm, as the case may be, I'll support the Constitution of the United States. Well, right, shall be administered in this form. This is what satisfies the 6th article of the Constitution. And so anybody who's going to claim authority over you in the United States has to have this oath of office filed, or they don't have any authority. And just because some attorney or some other fucktard tries to tell you different, puts in the comments that, dude's crazy and so forth. No, I'm correct. This is 100% correct. It's just, do you have the will to have it enforced? It's a matter of willpower, right? They want to will that you don't have this authority, that, hey, don't pay any attention to this stuff. It doesn't exist. No, it's the very first law passed. It does exist. And the ones telling you it doesn't are esquires, who are agents of the crown. So, with all that being said, back to the mother court. So I was talking about it in my last video, and I decided to try to put something in, which has been put in and it's been received, but I don't have a court case number yet, which is what it says in the rules. It may take a few days to get a court case number, but I didn't want to wait until then to do the video, so I'll just do it today. Right, they have this miscellaneous case cover sheet. Now, you don't find this at other United States district courts, right? This is just the Southern District of New York that I found. I'm not saying it won't show up someday, but as of today, this was the only place that had such a thing. Other courts have a civil case cover sheet. That's for the $400 case. This is for the $46 case, or $47 now. Miscellaneous actions. And the plaintiff is people of the United States, XRL. I'm going to be the relator, Robert Allen Retluski. And I'm the defendant, the government of the United States. Right? What's the description of the case? Petition government for redress of grievances for not enforcing the fundamental law of the United States and requiring all public officers to execute the oath of office in an act to regulate the time and manner of administering certain oaths. 1 Stat 23, the thing we just looked at. All right, so I'm trying to use this as a way to petition the government for the redress of grievances. Because as I showed, when you look at all the natures of the case in here, these are all to do with orders, petitions, subpoenas, all actions that were done by the Court of Chancery in England, not a court of law. Courts of law can only give you damages. And courts of law do everything as a legal fiction. But courts of equity give everything other than legal damage, or everything other than damages as a remedy, and they're only done in personam jurisdiction, right? In person. So it's like going to a different door of the court. This is the door we should be going into, instead of going into motion practice into a court of law where it's all legal fictions. And so on this form, they have all these different things you could put in. And, they have some pretty good ones. Like, they could check a box for M73 and subpoena to government agency. Right? You could check M52 and have an application for leave to file a complaint. But instead of me trying to pick which of these, would be the answer, I said, well, the thing to do then is just to petition the government for the redress of grievances. Tell the government what the problem is and let them figure out which one to pick. And that's kind of how I put it together when I did it. Right? But it's just a real simple 3-page form. Do you claim related to another miscellaneous case now pending? No, I don't. Yeah, doesn't go to anything else. Check at least one pro se. That would be me, right? Because I'm the party. I am the attorney for the plaintiff, people of the United States. This actually should be assigned to, I said Manhattan, because that's really where it all started, right down on the island, right, which claims to be a sovereign jurisdiction from the District of Columbia. That's what they said in one of those things I read earlier. So, okay, I can see where that would be. It's an island. It's its own little. This is where the United States started. It started in Manhattan, right? The first 10 years of the Congress, or until they moved to D.C. Well, no, they eventually went to Pennsylvania. But when they started out in New York. When George Washington did his inauguration, it was in downtown New York, right? Conducted by the Chancellor of the state of New York, which the Chancellor would have been over the Court of Chancery of the state of New York. So, there you are. Okay, because I was doing this all online because, you can't go to these courts now. Everything is being done by email, they've made special provisions for pro se plaintiffs or pro se parties to file their paperwork. Okay, and that's all in this here. If you go to the United States District Court, Southern District in New York, you can find this notice for temporary acceptance of pro se filings by email. It's everything that you need to do. But now I just want to read my, this is my public statement now about the complaint that I put into the United States District Court. And I didn't say Southern District of New York because really I'm putting it in the United States District Court, the big court, right? The one where the United States is the district. Not like a local court where it's just a municipal court for the Western District of Michigan. I don't want it in that court. I don't want it for the court. I want it in the United States District Court. So petition the government for the redress of grievances. Grievance. Government of the United States is not enforcing the fundamental law of the United States. For the people of the United States, I, Robert Allen Ratluski, a citizen of the United States and a veteran member of the Armed Forces of the United States, attest that the government of the United States is not enforcing the Constitution of the United States of America, ordained by the people as fundamental law of the United States and entitled Constitution of the United States. I'm not sure where that comes from. Hang on. So, I think it's kind of important that the title of the document is the Constitution of the United States. Right? And then its preamble, it says, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the welfare, general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So the Republic, United States, is establishing a Constitution for the democracy, United States of America, King George's jurisdiction, that them fucktards need to follow. But the problem is they're not doing it because there are no officers in the United States to enforce the Constitution. Right? Because nobody's taken a proper oath of office. In fact, if you go look at what's the president supposed to do, the executive power shall be vested in a president of the United States of America. But if you look at the seal behind that Trump stands behind, it says President of the United States. That's because an esquire didn't give the proper oath that's in Article 2 to Donald John Trump, and he did it on purpose. Where's the oath at, anyways? Oh, you never find these things when you want to. Hang on. There it is. Before he enters into the execution of his office, he shall take the following oath or affirmation. I do solemnly swear that I will faithfully execute the office of President of the United States and will do so as the best of my ability. Preserve, protect, and defend the Constitution of the United States. Right? There's no so help me God at the end, and there's no place to put his name. Well, both of those things Roberts added to the oath. So he didn't give him the oath that's in Article 2 of the Constitution. And he did it on purpose because he's a scheming fucking esquire. That's what they do. So that's what we're dealing with, and doesn't mean we can't use them to our advantage, right? They're just we're going to them, the judge esquires now, as trying to do it as an attorney, into motion practice in a civil case. And I'm saying, no, we don't do it as a civil case. We do it as a miscellaneous case, the $46 case, and we say, that we're going to be petitioning for redress of grievances. So anyways, back to the complaint. The United States and several states allege public officers are knowingly or not imposters because they have not executed the oath of office mandated by Congress that satisfies the 6th article of the Constitution of the United States. These persons, knowingly or not, are in violation of Section 912 of the United States Code, Title 18, it'd be 18 USC 910, or 912, and are warring with the Constitution of the United States. And 18 United States Code Section 912 says, whoever falsely assumes or pretends to be an officer or employee acting under the authority of the United States or any department, agency, or office thereof, and acts as such or in such pretended character, demands and obtains money, paper, document, or thing of value, shall be fined under this title or in prison no more than 3 years or both. Well, that makes it a felony. Right? It's a felony to anything more than a year is a felony. So it's a felony to pretend to be an officer of the United States. Well, you're pretending if you haven't taken the oath in 1 Stat 23/4 USC 101. That's the reality. It's just now, how do you get that enforced? Right? So that's what these people are. They've violated Section 912 of Title 18 United States Code. Anyways, per the 6th article of the Constitution of the United States, the senators and representatives before mentioned and members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Well, we just saw then the definition of esquires that they're taking an office of trust. Right? So, but there you go. All of these offices are in classes of offices spoken of in the 6th article of the Constitution have to take the oath that's in 1 Stat 23 because that's the law that says this is the frickin' oath that satisfies the 6th article of the Constitution. Right? As an act to regulate time, manner of administering the oath, 1 Stat 23, signed by President George Washington on June 1st, 1789, mandates in the first section. Being enacted by the Senate, House of Representatives, United States America, and Congress assembled, the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following to wit, I do solemnly swear, IAB, Donald John Trump, do solemnly swear or affirm that I will support the Constitution of the United States. In Section 3 of the Act, it says members of the several state legislatures and all executive and judicial officers of the several states who shall be chosen or appointed after the said first day of August shall, before they proceed to execute the duties of their respective offices, take the foregoing oath. Right? Shall be chosen, that would be elected or appointed. Have to take this oath. This mandated oath was incorporated into the United States Codes for USC 101, oath by members of legislatures and officers, specifically addressing the state officer's duty to execute the oath prior to exercising the power of office. And according to the 6th article of the Constitution of the United States, this Constitution and the laws of the United States, which shall be made pursuant thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So somebody in a state wants to say they're a judge, then they have to enforce this law. Right? Otherwise, they're warring with the Constitution. So alleged public officers of the several states are in violation of this Constitution and usurping the authority of the public office for not first having qualified for the office by executing for USC 101. It doesn't matter if they don't know this, right? Ignorance of the law is no excuse. They didn't follow the law. So that's your defense, right? Your defense is the truth. As a result, the states are denied the Republican form of government guaranteed by the Constitution of the United States. Aha! That's why it's important. Because if you don't have these people in place, you do not have a Republican form of government, and it's guaranteed to the state by the Constitution. Article 4 of the Constitution of the United States guarantees every state in this union a Republican form of government. and shall protect each of them against invasion and an application of the legislature or of the executive, and the legislature cannot be convened against domestic violence. Okay, well, I say I'm part of the executive branch of government here in Michigan because I'm a veteran. I'm still in the military. So I'm filing my complaint into this court as a veteran, and as far as I'm concerned, then it should be free, and this should be the Supreme Court. It was talked about in the Supreme Court rules, but in any case, I'm happy to pay $47 to have them agree with me. Right? So anyways, I'm going to use Michigan as an example of how the government of the United States broke its promise. Right? How it broke its promise that we do not have a Republican form of government. It's in Article 4 of the Constitution. So under the Freedom of Information Act, I requested the oaths of office officially recorded by the alleged governor of Michigan, Gretchen Whitmer. What I received in reply was not an oath found in what Stat 23 for USC 101, nor was it the oath of office required by the Constitution of Michigan in 1963, or any previous version of the state's Constitution. Gretchen Esther Whitmer, a.k.a. Gretchen Whitmer, is unqualified for the office of governor of Michigan because she evaded executing the oath that satisfies the 6th article of the Constitution of the United States. She had a duty to take it, and she didn't. She evaded the oath. I don't care what her excuse is. She evaded the oath. She's not the governor. So they weren't trying to kidnap the governor. They were trying to, if they were doing anything, they were trying to kidnap an imposter. But still, it would be kidnapping, right? Because they're going to take her across state lines. They were going to go to Wisconsin, apparently. That'd make it kidnapping, take somebody beyond state lines, where they should have. Now, this is what the Berry County Sheriff said, that he saw that they weren't trying to kidnap her, that they were trying to arrest her. And what they should have done is arrested her and taken her to the sheriff's office and turn her in. But that's what they're saying they did. No, they're going to take her across state lines. Well, that's where the kidnapping would come in. That's what would make it a federal case instead of state, and right? She also counterfeited the oath required by the Constitution of Michigan of 1963 by filing with the Michigan Department of State a document with an altered oath text subscribed under a nickname, Gretchen Whitmer, and witnessed by a class of officer, state officer, unauthorized to administer an oath of office to the governor. Exhibit 1 is my request for the oath of office in the state's reply, right? So basically, I just copied my request to them and what they gave me back and put an exhibit on it. I'm giving it to them. So here's my exhibit, right? Imposter Whitmer is not alone in the impersonation of public officer of Michigan. Request for other state officers' oath of office leads to the same result. No person claiming an office authorized by the Constitution of Michigan in 1963 has filed the federal oath of 4 USC 101 or executed a valid state constitutional oath. As a result, the state is denied a Republican form of government guaranteed by the Constitution of the United States. That's my argument. Forget everything else. The state of Michigan does not have a Republican form of government because none of these people have taken the oath of office required by the Constitution. It is my belief none of the several states has qualified public officers for Republican form of government. So what's supposed to happen then? Right? Well, it's guaranteed shall protect each of them against invasion. I guess that's what's happened. We've been invaded because we don't have a Republican form of government. Come on, Army. I'm waiting. Staff Sergeant Robert Allen Ratluski is waiting for some relief. Where are we? This constitutional crisis is not limited to the several states. Oh, no. It's much bigger than that. President-elect Donald John Trump has been denied the Article 2 office of President of the United States of America because Esquire John Glover Roberts Jr. incorrectly administered the Article 2 oath, added Donald John Trump, and a religious test to the president-elect requiring a redo of the oath. Donald John Trump must also execute the oath of 1 Stat 23 to satisfy Article 6 of the Constitution of all executive branch officers. That's because he's the chief executive officer and the commander-in-chief. Alleged senators and representatives did not comply with Article 6 of the Constitution of the United States. Instead, they executed false oaths that contain a religious test, so help me God, subscribed using a pseudonym or nickname that was filed in a manner contrary to law. Exhibit 2 is these particular pages, H712 to 715 of the House section of the Congressional Record for January 17, 2019. This record shows that the alleged members of the House of Representatives filed documents after the adjournment for the day as oaths of office of a representative and also for access to state secrets using a false identification on a color of law simulation of legal process for the act required to be performed. The act they're supposed to do is 1 Stat 23. They didn't do it. The judicial branch of the government of the United States has been abandoned, and no Article 3 judicial officers exist. Persons claiming to be a federal judge did not execute the oath in 1 Stat 23, swore an oath with a religious test, and do not have a valid commission issued by the President of the United States of America under the Great Seal of the United States delivered to said judicial officer. These are all things that would have to be done for somebody to be an Article 3 judge. They didn't do them. Executive branch officers file a document entitled Appointment Affidavits, which is the U.S. Office of Personnel Management Standard Form 61, not an oath of office. The filing of this appointment affidavit simulates a legal process under color of law and causes a deprivation of rights of citizens of the United States. It does not contain the form of oath required by 1 Stat 23, and it bifurcates the oath found in 5 USC 3331. That itself is unconstitutional because it contains a religious test. Right? They just fucked it up all sorts of ways. They're not in the government. Come on, Army. Jeepers, creepers, man. As a result of a scheme by conspirators warring with the Constitution of the United States, there are no qualified officers of the United States to enforce the laws of the Constitution of the United States, leaving the citizens of the United States and states denied a Republican form of government guaranteed by the Constitution. An actual fact, as a requirement of Article 2 of the Labor Code of April 24th, 1863, also known as the General Order number 100, have not been complied with. The United States is and has been under martial law since President Lincoln declared the same in 1861. Right? They didn't do what Article 2 says of the Labor Code to get out of martial law. It had already been declared. It's what needs to happen. It's not happening. The display of the gold fringe flag of the United States is controlled by Army Regulation 840-10. Hey, we looked at that. And this regulation makes no provision for this style of flag to be displayed by a civilian government. It is this flag, the gold fringe, that is displayed in courtrooms and offices of government, and as long as it remains on display, it is evidence that the United States is under martial law military rule, and that the courts, including SCOTUS, are military tribunals and not courts of civilian government under the Constitution of the United States. Right? They're military courts. And there's multiple kinds of military courts. But the one at the top is called the General Court Martial. If you've been in the military, you have privilege to a General Court Martial. So tell them you want to be tried by court martial. They can't do it. See, this is the reason you do that. They can't do it because somebody has to actually step forward in their proper person and press a charge against you. And they can't because they're all lying, cheating, and stealing. The United States is at war, and persons claiming authority under the United States that conceal their full name identification on simulated legal process they submitted as an oath of office are to be considered spies and saboteurs until properly identified and empowered by the United States Army to be a member of the wartime government. That's how shit works in a war. The Army's in charge. It's not the Navy. That's nothing to do with the frickin' Navy. This is all about the Army. As there is no functioning Congress of the United States, right? Because none of these people have proper oath of office. The imposters in the Capitol building must be captured if possible, killed if necessary, but in any case, driven out of the United States. Do you think that they're going to come and arrest me because I said kill them if necessary? I don't think so. That's what the Army does, right? There is no middle ground. You will either surrender or die. And that's where we're getting to, because that's where they have pushed it to. Congressional impersonators are enemies of the United States, so are Esquires, and I demand that they be removed from the Capitol, and that the United States Army do what is necessary to install Donald John Trump as Commander-in-Chief, so he can end the Civil War, restore the civil rule to the nation, and all other relief the United States Army can provide. I declare under penalty of perjury that this foregoing is true and correct, executed on October 6th, 2020. Okay, so that was, the blah blah that I sent them. And just to show you that, that if you contact your state, that's what I did. I contacted, who did I contact? Michigan Department of State Freedom of Information Act, written request for an image of the oaths of office subscribed by Gretchen Whitmer for the governor, for the office of governor of the state of Michigan and its commander-in-chief. And they said, okay, well, here you go. This is what we have for her, which is this document here, which looks like it's the text out of the Constitution for Michigan, or Michigan Constitution of 1963, except for the fact that this thing here where it says Constitution of this state is all lowercase in the Constitution, where here it's been made a proper case term, Constitution of this state. So now it's like we have two different constitutions, the Constitution of the United States and the Constitution of the state, which, what state are we talking about? State of Michigan. Well, there is no state of Michigan. Right? So they changed the meaning of the oath by changing the capitalization of two words. But it goes on, right? She didn't use her full legal name, right? Gretchen Whitmer is not her name. And it was sworn before notary. And I don't remember the law. Well, I do, right? Take notice. The style of oath was altered and is not the oath required by the Constitution of Michigan of 1963. Gretchen Esther Whitmer concealed her full legal name on this official document, and a notary public is not authorized by the state law to administer the oath to the governor. That'd be MCL 1537. And here's this stuff about the Exhibit 2, right? This is for the members of Congress, January 17, 2019. After they adjourn for the day, they're going to act like they're filing these oath of offices that they say satisfies the 6th article to be administered. Jeepers. The oath of office required by the 6th article of the Constitution of the United States, and as provided by Section 2 of Act something or other, to be administered, text of which is carried in 5 USC 3331, right? I state your name, do solemnly swear, so help me God. Well, that just made it, by putting so help me God in, unconstitutional. So this isn't the oath that satisfies the 6th article of the Constitution, because it's got a religious test. But you see all these people are using nicknames or, partial names, or I don't know what you want to call them, right? They're not using their full legal name. And so they did that to pretend to become a representative. And then they did it again to get an oath for access to classified information. All right, well, this makes them all a fucking spy because they're using a fictitious name. All right, so that's what that was all about. And then here's the appointment affidavits that are filed by, alleged executive officers, like an FBI agent or whomever. In this case, it's the chairman of the Board of Governors of the Federal Reserve System for a term of 4 years. Right? And it's I, Jerome Powell. Well, Jerome's got a middle name. It's not on here. And then you see what they did is added this line here, right? A oath of office, which isn't in the oath. If they were using the oath in 5 USC 3331, which is what he's supposed to be taking, they say, it wouldn't have this line in here. So this oath has been bifurcated, which is why it's no longer called an oath. It's just called appointment affidavits, right? Affidavit, and something that really isn't an oath of office. So it just goes on and on and on, right? None of these people have any authority in any position whatsoever. So that was what I filed, under this miscellaneous. That was this one. But what I'm going to do next, because, I had to do this first because it's the right thing to do, to complain about the big picture. Study yourself. But in Title 50, which is the Civil Service Act, I think is the proper name, right? They have this thing in here about certificates of service. So if you're a veteran or a member of the military, you're going to want to write this down and remember this, right? This is in 50 USC United States Code, Section 4012, certificates of service. That in any proceeding under this chapter, well, then in any proceeding whatsoever, a certificate signed by the secretary concerned is prima facie evidence of the following facts stated in the certificate: that the person named is or is not, has been or has not been in the military service, that the time and place the person entered the military service, the person's residence at the time the person entered the military service, the rank, branch, and unit of military service of the person upon entry, the inclusive dates of the person's military service, the monthly pay received by the person at the date of the certificate's issuance, and the time and place of person's termination or release from military service. Right? So this will tell you if you've been released or not. Not from active duty, which is all a DD-214 is supposed to show, but from military service, from the custody and control of the military. The secretary concerned shall furnish a certificate under subsection A upon receipt of an application for such certificate. A certificate appearing to be signed by the secretary concerned is prima facie evidence of its contents and of the signer's authority to issue it. A service member who has been reported missing is presumed to continue service until accounted for. This is why I'm saying if we get these things, they're going to show that we haven't been released yet. We're just, being carried as missing. A requirement under this chapter that begins or ends with the death of a service member does not begin or end until the service member death is reported to or determined by the secretary concerned or by a court of competent jurisdiction. And a court of competent jurisdiction is a court acting as a court in chancery, where it's all in personam jurisdiction. And in a court of chancery, one of the maxims of a court of chancery is that it can't give you partial equity. It has to give you complete equity. So that's why trying to ask for just something, one of these particular things may not be enough. And it's like, well, instead of asking for a specific order or something, just tell them what your problem is as a petition government for redress of grievances and let them figure out what to do. But that's what I plan on doing. I'm going to have them ask for this certificate for me to figure out what my status is. Right? Because I say I'm still in and that I should have an ID card and that I'm authorized to have retirement, but I'm not getting it and da-da-da-da. And, hey, the easiest way to get it figured out is just get this certificate because it's prima facie evidence. Now, what they have you do under this act right now, they're supposed to follow this act if they take you to court. It's the Service Members Relief Act, Civil Relief Act, right? They file a piece of paper that comes from somebody acting under the authority of the Secretary of Defense. But that isn't who it's supposed to come from. It's supposed to come from the Secretary of your service. right? So, the one that they lead you to go get is not the one that's talked about in this particular act. So that's my plan, right? Is the next one I'm going to file, which I hope to do this week, about veterans and our, that we should all be in the military, should all ID cards, so forth and so on. And here's how you can prove what my status is. Let's start there. What's my status? What page did I say I was on here? 47. A bit easier to find this way. Right? Section 4012, Certificates of Service. Persons reported missing. I think that we're all, being carried as missing. Because most people's DD-214s don't say they were discharged from the military. It says that they went into the reserves, or in other ones, it says that they went on leave, unpaid leave. But it doesn't say anything about being released from the military. So don't let them say that you were released from the military just because you have a DD-214. That's an incorrect statement. Told you by an Esquire, who I'm telling you, they're enemies of the United States. Just started treating them as such, and we can soon get this mess straightened out. Because they're supposed to be learned in the law, yet they lie, cheat, and steal. Right? The things they're doing are done in bad faith. They're done against the Constitution. And, well, now, because, the United States is still under military rule, it's up to the Army to come and enforce the Constitution in the United States. So what should happen here, with any luck, just so I'm going to leave it here, right? But now that this has been put in, what should happen next is that this gets a court case number, right? That according to this notice here that they put in, right? That, where is it? Filing by pro se litigants submitted by email must be sent to this particular address and done in accordance with the procedure that they say has been attached. And then you should ask, also encouraged to receive electronic service, which I did also. Right? Procedure for emailing a pro se document for filing. Email it to this particular email address, and you got to sign it one of these three ways, right? Sign by hand, scan it, sign electronically, or put S with the filer's name. New case, the subject line must read pro se, filing new case. Check, 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 right? Checked all these boxes and submitted it in, and it said new cases for which a filing fee is to be paid. Payment must be sent separately by mail within 21 days of filing. Okay, well, it still isn't filed yet because I don't have a court case number. Right? But that's the wonderful thing is I get 21 days from the time that they actually file it to pay for it. So I'm just waiting to see if it's been filed. But it says 14 days after mailing any new file case, pro se filer should call pro se intake unit to learn the case number and name of the assigned judge. Right? So that would be one way to do it, but the other way is to have a Pacer account, and it should show up on Pacer. So that's what I've been doing so far is checking Pacer, but here this week I will call this phone number and see if they've given me a court case number yet. Sign up for email notifications, right? Pro se parties without electronic filing privileges but an email address are strongly encouraged to consent to receive electronic service of filing through notification sent by email from the court's electronic case filing system. That's what I'm doing right now, waiting for that to happen. Okay, well, that's a lot of, blah, blah about different things happening, but those were those particular items of interest, but this other one is all by itself, right? This is that one to do with the post office, about applying to get a post office caller service, which I'll be checking on this week and do a video on the stuff to do with the post office I've done over the last week and a half, in another video. It's just a little bit too much to do at one time. So, okay, I'm going to leave it there. I'm done talking, and you're probably tired of listening to me. So, have a great day. Take care.